When you're handling a case against the MTA, you've got to question every given. They're not very free in how they give out information, but over the years we've used a number of different devices available to the public and to attorneys to get information that we otherwise would not be provided. You do a notice to produce. That's a discovery demand where you ask for delineated items of information, operator manuals, training materials for MTA bus drivers. Normally you get nothing from the TA. They just kind of ignore that, and unfortunately sometimes the courts themselves are not as much of an ally as you would like them to be in this undertaking. Because remember, we're just trying to find the truth. I'm asking for something as simple as, can you give me the training materials for this operator? Can you give me the manual that he was trained with? They just don't give you these things. We use a number of different devices outside the normal discovery process to get this information. One of them is a Freedom of Information Act request, often referred to as a FOIL request by people in our business. And sometimes you get more from a FOIA request than you can get from a notice to produce. We've been successful over the years in getting the training manuals for the bus operators, and oftentimes you can find by their own testimony they're violating their own procedures, and that can be very helpful. It doesn't necessarily mean they were negligent in that case, but you can use that as an indication and as a showing of negligence that they disregarded their own internal regulations. And it certainly is helpful when you put a bus operator on the stand and say, "Sir, I understand you're doing your best that day, but is it fair to say that your operator manual says X, Y, Z? And it's fair to say that if you had to do it all over again, sir, you wouldn't have done it that way, right?" Right. And then to bring his supervisor in and ask the same series of questions again. So you've got from two witnesses from the MTA admitting that on the day of this accident, they didn't follow the ideal way that they should have to operate their vehicle. And that can be very helpful. In addition to the FOIL requests, we also get so-ordered subpoenas asking for information. And one of the things I learned over the years is that in a big company such as the MTA, the requests go to different people based upon the way the request is made. It may be that the FOIL officer is a different type of person. Maybe they take their obligation very seriously, and they're going to make sure that they fulfill their duties under the law, and they make an exhaustive search for the record you're seeking. And all of a sudden, instead of getting 10 pieces of paper, you got 63 pieces of paper. And then it could be that the so-ordered subpoena goes to a different person entirely. And that person's either, not very active, lazy, doesn't care. Either way, it's your job as the lawyer not to trust what you've been given, but to push for more. You don't always know what's there, but experience can tell you what they're not providing you. If you have a checklist, for example, of what the MTA is supposed to do after every accident, which we have that checklist, and they give you 7 items, and you know that there's 20 items on the list, you know they haven't given you a lot of the material that you're entitled to, that they're required to provide. Age, experience, exposure, it really does help you. And what I love about practicing in this law firm is it's not just me. I've got 20 some odd other attorneys in this office that come here armed with different experiences. We're seeking the truth, and sometimes you could say, "Oh gosh, I'm tired. They've given us 19 out of 20 items. What are the chances that that 20th item really makes a difference?" Well, it could be the entire case. And it's your job as an attorney to keep on digging, keep on working until you have every last piece of evidence in the world. And there's nothing more important on a case, an accident case, than physical evidence. You gotta show up every day as a trial lawyer, as a working attorney. You can't be asleep. You can't just say, it's gonna work out. It's only gonna work out if you do your very best and work yourself to the bone. That's what wins cases.